In this lesson, we're going to begin our discussion of the Erie Doctrine. As you can see up here on the board, we have a four-step approach to deal with Erie. We can go ahead and just jump right into it with step number one, which is just going to be some basic issue spotting. Step number one, of course, we want to determine whether Erie could be an issue in our fact pattern. How do we do this? Well, we say when a federal court is adjudicating a state law claim, the Erie Doctrine considers whether that federal court should apply state law or federal law to the issues presented before it. So the first thing to recognize off the top here is we need a federal court adjudicating a state law claim for Erie to be at issue. What happens if we have a federal court adjudicating a federal law claim? Well, if we have a federal court adjudicating a federal law claim, meaning that court is sitting in federal question jurisdiction over that claim, then the federal court's just going to apply federal law. Okay, there's no issue as to whether the federal court should apply state law or federal law when the federal court is adjudicating a federal law claim in its federal question jurisdiction. Okay, so if we have a federal court adjudicating a federal law claim, then we're just applying federal law. We don't have to worry about an Erie Doctrine analysis. So Erie Doctrine is only going to be an issue if we have a federal court adjudicating a state law claim, which typically means our federal court will be sitting in diversity jurisdiction. This is typically how a state law claim is brought into federal court. Okay, and then from there, usually in terms of issue spotting Erie, we're going to have some dispute. The plaintiff who files the state law claim in federal court is probably going to want federal law applied to some issue presented in the case, and our defendant is going to want state law applied to that same issue, and the federal court's going to have to make a decision. The federal court's going to have to think to itself, well, on one hand, we are a federal court, so should we apply federal law to this issue? On the other hand, this is a state law claim. Should we be applying state law to this issue? Right, the court grappling with this decision and basically how they decide which one to apply, federal law or state law, is our Erie Doctrine analysis. These are the four steps we have on the board that we're going to work through in this lesson. So this is how we issue spot it. Okay, and kind of the way this plays out, probably the best way to just see a fact pattern, like what does it look like, is to go directly to the source and think about Erie Railroad Company v. Tompkins. This is a case worth keeping in mind as we work through these steps. This is a very seminal, landmark Supreme Court decision in civil procedure. So this is a case we want to kind of keep in mind. And I think the fact pattern here is really going to illustrate kind of the facts we're looking for when we're issue spotting Erie Doctrine on a fact pattern. Okay, so in Erie Railroad Company v. Tompkins, we have a plaintiff from the state of Pennsylvania. We have Tompkins, who is a citizen of the state of Pennsylvania, and we have our defendant Railroad Company, who is a citizen of the state of New York, right? Erie Railroad Company. And basically, we have Tompkins one night in the dark walking along the railroad tracks. And of course, as he's in the dark walking along the railroad tracks, a train comes passing by on the tracks, and there's an object protruding from the train. Tompkins believes it's an unlatched door, but in any event, some sort of object protruding from the train hits Tompkins, right? And as a result of this impact, he sustains really serious injury. So Tompkins wants to sue the defendant Railroad to recover damages. Remember, they're diverse parties, so he brings his state law tort negligence claim to federal court, right? In order to recover damages for this injury he has sustained as a result of this object protruding from the train striking him. And he's able to do this because there's diversity. The federal court has diversity jurisdiction to hear this state law claim. So immediately, when it gets to federal court, the defendant Railroad Company files a motion to dismiss. They say, hey, wait a second here. Under Pennsylvania state common law, this guy Tompkins was a trespasser. He was trespassing on the railroad. And we know in torts under Pennsylvania state common law, we owe trespassers a far lower standard of care. In fact, in those cases, the plaintiff has to prove that we were willfully or wantonly negligent to prevail in the action. And Tompkins has not alleged in his complaint that we were willfully or wantonly negligent. So you, federal court, should dismiss this action. And of course, our plaintiff Tompkins responds and he says, "Who cares what Pennsylvania state common law says? We filed this in federal court. And pursuant to Swift v. Tyson, we can have the federal court apply its own federal general common law principles." And the federal court could say, look, I was an invitee on the land, so you owed me an ordinary standard of care. And so ultimately, the federal court here decides to follow precedent, which was Swift v. Tyson, a former Supreme Court decision, and they apply federal law. And the plaintiff ultimately prevails and recovers damages. Of course, the defendant railroad company challenges this all the way to the Supreme Court, and we get our decision in Erie Railroad Company v. Tompkins that everybody knows today, right? Which is essentially, right, Erie overturns Swift v. Tyson and says, really, this analysis comes down to substance versus procedure. Federal courts should apply state law to substantive issues and federal law to procedural issues. And don't worry too much about the difference between substance and procedure. We're going to break this down in a ton of detail when we get to step number 3. We'll get into substance versus procedure when we get into step number 3. The point of understanding the fact pattern in Erie Railroad v. Tompkins is that's typically, from an issue spotting perspective, how these things play out. We have a plaintiff bringing a state law claim in federal court, usually based on diversity, and then ultimately there's some issue where the plaintiff wants federal law applied to that issue and the defendant wants state law applied to that issue, and the federal court has to decide, are we applying federal law or are we applying state law to this issue? That's kind of step number 1 now is triggered. Then we go to step number 2, and we need to determine in step number 2 whether the decision that this federal court is making between state and federal law is within the scope of Erie. Okay, so we find in a future Supreme Court decision, Hanna v. Plumer, that there's actually some scope and some limitations put on this analysis, and that's what we need to consider in step number 2. Essentially, when there is a conflict between state law and a federal rule of civil procedure, or really any other statutory federal rule of procedure, but typically in civil procedure fact patterns, we're dealing with the federal rules of civil procedure. That's why I have it written this way. But again, when there's a conflict between state law and a federal rule of civil procedure in a diversity case, such that both the state law and the federal rule of civil procedure cannot coexist and be applied at the same time, the analysis as to which law applies is outside the scope of the Erie Doctrine. These cases are governed by the Hanna v. Plumer line of cases. So, off the top, the major distinction between Hanna v. Plumer and Erie is the source of federal law. Okay, if the federal court is making some decision between whether they should apply state law or federal law, if the source of the federal law is statutory, in most cases this would be like a federal rule of civil procedure, generally we're going to say that analysis as to which law the federal court should apply is outside the scope of Erie Doctrine. We're going to apply the rule from Hanna v. Plumer. Okay, however, if the source of the federal law is more like Erie, it's based on federal judicial precedent, Then we're going to say, okay, that's within the scope of Erie Doctrine, and we go to step number 3, and we say, okay, if the decision is within the scope of Erie, we apply the Erie Doctrine to determine whether state or federal law should be applied. Okay, so let's break this down though in a little bit more detail. Let's just talk about what Hanna v. Plumer is. So essentially, in Hanna v. Plumer, we have Hanna suing Plumer in federal court, okay? And Hanna serves Plumer notice of the lawsuit, right? Service of process by delivering copies of the summons to Plumer's wife, okay? And this is a valid way to deliver notice of a lawsuit, to deliver service of process pursuant to Rule 4 of the Federal Rules of Civil Procedure. So under federal statutory law, Rule 4 of the Federal Rules of Civil Procedure, this is a valid way to deliver service of process. Okay, so Hanna does it correctly based on federal law. However, it turns out under Massachusetts state law, this is not a valid way to deliver service of process. Pursuant to Massachusetts state law, service of process has to be hand delivered to the defendant. And remember, that's not what happens here. Hanna does not hand deliver service of process directly to Plumer. The copies of the summons go to Plumer's wife. Okay, so the federal court hearing this case in Hanna v. Plumer, again, this is a federal court sitting in diversity jurisdiction. This federal court has to decide, do we apply the Federal Rule of Civil Procedure or do we apply Massachusetts state law? And in this case, they actually decide to apply Massachusetts state law. So Plumer files a motion for summary judgment. He says, look, I was not properly served notice of the lawsuit, and the federal court agrees because they apply Massachusetts state law. And they say, well, under Massachusetts state law, you have to hand deliver the summons to Plumer. That didn't happen, so we have to grant his motion for summary judgment. This goes to the Supreme Court, and the Supreme Court says, okay, in this situation, this we're going to say is distinguishable from Erie. Okay, in Erie, again, the source of federal law was based on judicial precedent, what we might call federal common law. Here, the source of federal law is statutory. It's a federal rule of civil procedure. So basically what the Hanna court says is the federal rule of civil procedure is going to apply. If we have a direct conflict between state law and a federal rule of civil procedure in a diversity case in federal court, such that both the state law and the federal rule cannot coexist and be applied at the same time, the analysis is outside the scope of Erie. This is very different than in Erie where we had this federal judicial precedent, like federal common law. This is a federal rule of civil procedure enacted by Congress and approved by the Supreme Court, right? Reviewed by the Supreme Court, sent to Congress for enactment. This is very different than some precedent at the federal level, okay? And so for those reasons, basically the Hanna court says, this is a Supreme Court decision, that the federal rule of civil procedure is going to apply in that situation so long as it's valid, which basically just means so long as it's constitutional and it complies with the Rules Enabling Act. And for our purposes, we can basically just assume that the federal rules of civil procedure are constitutional and comply with the Rules Enabling Act. It would be exceedingly rare that it would be unconstitutional or not in compliance with the Rules Enabling Act. So for our purposes, really, if there's a conflict between a federal rule of civil procedure, and I mean a direct conflict, such that that rule cannot coexist and be applied at the same time as the state law rule, the federal rule of civil procedure is going to control. And this would be basically any federal statutory law that is procedural. But for our purposes, again, if we're in a civil procedure essay type question, it's generally going to be a federal rule of civil procedure, as was the case in Hanna v. Plumer. Okay, so step number 2 is all about scope, and the main takeaway we should have here when we're thinking about step number 2 is, what is the source of the federal law? If the source of the federal law is statutory, remember, if we have a federal court adjudicating a state law claim in diversity jurisdiction, and they're having to decide whether they're applying state law or federal law to some issue that's been presented before them, in this case, if the source of the federal law is statutory, that's more like Hanna v. Plumer. And basically, the court's just going to say, as long as that federal statutory law is valid, it applies. We don't go through this whole Erie analysis. It's just outside the scope of Erie. We're just going to say, look, in that case, because it's statutory, federal rule applies. Okay, but if the source of that federal law is based on judicial precedent, basically stare decisis, right? Common law, then Erie applies and we move on to step number 3, okay? And that's more like what Erie Railroad v. Tompkins was about. Remember, it was based on federal judicial precedent, not federal statutory law. Okay, and remember, another important point to make here before we go on to step number 3. We're talking about the situation where we have a federal court adjudicating a state law claim. If the federal court is adjudicating a federal law claim under federal question jurisdiction, we just apply federal law. We don't have to worry about any of this stuff. Okay, so what we're talking about is a federal court adjudicating a state law claim in diversity jurisdiction. So if we have a conflict between state and federal law where the court is adjudicating a state law claim, it's usually going to be some sort of procedural federal law. Right? It's not a substantive federal law, because if it was substantive federal law, the court would be sitting in federal question jurisdiction, and none of this would be at issue. Okay, so that's why typically if we see this conflict, it's usually a conflict between state law and a federal rule of civil procedure, like is the case in Hanna v. Plumer. Okay, but that's step 2, that's determining scope. So, if we determine Erie is at issue, so that means we have a federal court adjudicating a state law claim, and there's some question as to whether the federal court should be applying federal law or state law to some issue presented before the court, and the source of the federal law is not statutory, it's based on common law principles, then we go to step number 3, and we say, so that means if the decision is within the scope of Erie, we apply the Erie Doctrine to determine whether the state or federal law should be applied. Okay, and the actual rule here under the Erie Doctrine from Erie Railroad v. Tompkins, remember, is pretty straightforward. Under the Erie Doctrine, when a federal court is adjudicating a state law claim, the federal court must apply the law of the state in which it sits to substantive issues. But of course, we know federal courts apply federal law to procedural issues. Okay, so an important note I would make here when we're finally now thinking about substance versus procedure, which is the heart of our Erie analysis. The important note I would make here is to not try. Thank you so much for watching this video preview of our Legal Education Accelerator Program, or LEAP for short. If you would like to see the conclusion of this video and gain full access to our entire 1L and 2L video library, integrated outlines, streamable audio versions, additional practice exams with explanations, and much more, we invite you to head over to our website and join the thousands of law students who have already enrolled. To get started with your no-risk free trial today, simply click the link in the description box below or visit www.studicata.com/leap.
Hi everyone, my name is Serena and I'm currently a law student at South Texas College of Law, Houston.
Hi everybody, my name is Shiva and I'm currently a law student at Southwestern.
Hi everyone, my name is Michelle and I am a first year student at South Texas College of Law, Houston. I used the Studicata study video series last semester to help me prepare mostly for contracts, and I actually made an A+ in contracts last semester, which I greatly dedicate to the Studicata videos.
By using Studicata to help me prepare for my final exam, I was able to score the highest grade out of my class on the final and even have my essay distributed as the model answer. Not to mention I had done quite poorly on the midterm and was struggling throughout the whole course of the semester, understanding the material and keeping up with lectures.
Because of the Studicata video lectures, I was able to go into my exams with a feeling of confidence. I didn't have to worry about what the rules of law were or how I was going to organize my answer to an essay question.
I would absolutely recommend the Studicata series and their online course materials to anyone. I think that they are not like professor lectures that you might find online or other outside study materials that you may encounter. I think that the Studicata videos really focus on not only ensuring that you understand the material that you're going to encounter on your final, but they also help you to understand kind of the best method for test taking, and they really break down how to approach each problem and the best ways to tackle certain methods on testing, and I think that's really important, and I think it's really special. I don't see that anywhere else in any of the other online resources that I've found. So I would certainly recommend Studicata to anyone who is studying in law school right now. Good luck on your studying and you're going to do great.
I would definitely recommend Studicata to anybody watching this video. Give it a chance. I'm positive that you will love it, that you will get a lot out of it, and that you will be happy that you gave it a chance. I definitely am. I know I will be using Studicata in the future.
And I cannot thank Studicata enough for getting me through my first semester of law school. I will definitely continue to watch the Studicata video lectures throughout my law school career, and I highly recommend that any future or current law student do the same.